I reflect back on why working statement, and I see it lies with the fact that India is a developing country, and when we start seeing it's a developing country, the needs of the developing country, then it's important that we see the like overall development happening. So on the science area, the technology area, if there is a patent and nobody is working that out, that's the fear, that patents should not be used just for blocking, but the benefit of the patents should be there for the society, and that as the mean to develop further. I also see that somewhere we are differentiating or distinguishing between is the act of publishing the patent application, is that enough, or should you start working that out? What I see is if I take that maybe in the past, when we have a limited people like who are technology specialists, then from the patent which is published, to take that knowledge and start implementing, this is not something easy, and therefore the organizations, the business organizations, the manufacturers, I see the obligation very much that it's not enough that you only publish the patent and leave it at that, but you take some step to also make it available to the society, to so that the society can make use of it and thereby get developed. So the intention of having this working statement for me comes because we are moving from a developing country to more developed things. So, and to see patents which are not blocking but is available to the society at large is always been considered very important, and therefore all these subsequent procedures have about working statements have followed. That's my understanding.
That's it.
Yeah, is there any other opinion here?
Well, not really another opinion, but I do see that actually working of patents in terms of using patents is more and more a topic outside India as well. Whenever we negotiate joint development agreements with universities, or whenever there is European funding, for example, there's always the discussion on what we call anti-shelving, because other parties are always afraid that certain technology will be protected by patents, put on the shelf and not used, and therewith not brought to the end customer. And as Philips, actually, we also feel that we should avoid that from happening, because we're there to bring technology to the patient in the end in the healthcare situation. And whenever there is an option for others to do that on technology that we have not commercialized ourselves, because of course we develop so many technologies that we will not be able to put products on the market for each and every one of them, we feel we should then be very open towards startups, towards research institutes to further develop that technology and put it to market. So any request we get in relation to, do you use the patents, what's your plan, can we get a license, will always be very seriously considered. So in that respect, I think that the jurisdictions are coming much closer together, and maybe you are ahead of us in actually making that clear in your laws in India by requiring the working statement to be there. Having said that, I know there's a lot of admin around it, and Chitra's team is actually helping us to sort out all the details around that, and I admire that, because I do think if there is a working statement like that required according to law, that it should be made as simple and straightforward and efficient as possible for everybody to be compliant, because otherwise the system will not work.
I'm just going to bring this a little closer. So I'm just going to paraphrase the question again, because you might have missed the question. If I can just paraphrase it again. The question, I think, was, what challenges do you see in e-filing the working statements this year? Okay? And I'm going to take a different slant at answering it from the other panelists. The challenge here is e-filing. The key word here is e-filing. Okay? That's the big change this year. Previously, we've always had to do working statements, paper it, write it out, send it in. Who would see it? Nobody. Now that it's e-filed, who's going to see it? Potentially a lot of people. That's where the risk is, that's where the challenge is, and that's when you're filing the working statement, you really got to put on a different hat and think about someone's actually going to see this now. And what am I putting down? Am I putting down too much detail? Am I putting down enough detail? What is the requirement that the law has in terms of putting something down? Okay? Sometimes you might want to just group a whole bunch of patents together and put it down as a statement saying this product has the following patents and so on, or this patent is covered in the following products. You have to be more careful this year. I think there's a very big challenge this year because what the government is heading towards is throwing all that information out on the internet and then allowing the marketplace to use it and to use it for you. You can use it for you and you can use it, and the marketplace can use it against you. I think that's where the challenge is going to be.
Yeah, thank you, Vipin. And I think this is a good one. It's the challenges. I hear the people here say, what is the rationale? It's when you have a patent, you don't use a patent as a block the other company to get into the market. But I think instead of asking each company to go through this burden to file these, and there's other ways. For example, if you actually want to get into the market and somebody try to block you, you can go to the court. Those cases are relatively smaller cases. We can handle it in that way instead of ask every patent holders, especially nowadays. We have electronic area, telecommunication area. Every little, like these cell phones, have thousands of patents in it. And how can you know which one you get into it? I believe there is a working statement at a certain place, you still have to say whether your license also put some value, dollar value into it. This one, especially like this year, we're gonna do electronic filing. Once you file it, theoretically, if government wants, everybody can see it. And then they still, at the end of that, you have to sign, basically, this statement not true. I don't know how many patent holders, especially nowadays, like an IT company, actually know how much money you can put into each patents, right? That's really challenging. And also putting the information there, and if somebody else can see it, I see there's a potential risks over there too. For example, in the US litigation, and sometimes they have to some discovery, and you put the information here. If somebody see, oh, you put a patent like that, if somebody, your competitor have a patent read onto your product, and you said, oh, you have something here which is generated a certain amount of value, you are basically expose yourself to a lot of risk. So in that sense, to me, I still don't understand the benefit is that still weigh the benefit and the burden here and the risk here. I still can't see the benefit overweigh the burden. The risk is here.
I think the issue is it on? No. I think the real issue is, do you need all the information? I guess from a U.S. perspective, it's true for the damages analysis and the potential, people coming out requesting damages, or whatever, forced licensing. The issue is, why would, maybe you want to say that you work the patent. I mean, I guess that could have value, but having to say the value of all that, to me, is questionable. Like, why does anyone need that?
Yeah.
So.
Yeah.
Well, maybe I could add to it, and in fact, I'd like to also add here that under Section 69 of the Indian Patent Act, it's the licensee has to register the license with the Indian Patent Office, right? Well, it was mandatory a few years back, it's not mandatory now. But when you look at the working statement, the section says that all patentees and licensees should be filing a working statement. Now, coming to the point of e-filing and the fact which was just mentioned that it's now open for everyone to look at, if there is a licensee and a patentee who has independently filed those working statements, and if there is a discrepancy in the figures, can this be considered as a false statement by either of these? Because if it is a false statement, then the penalty is harsh.
Yeah.
There's a fine as well as imprisonment, if I'm not mistaken.
No, you're not
Yeah, I don't think anyone would want to get into that. I mean, and the problem is that sometimes the patentee and the licensee do not have direct control over each other, and that could create to some discrepancies. So the fact is, maybe either party decides, well, we'll not file it at all, and that also has a penalty. Of course, not as harsh as a false statement, but there's a problem there. So I think there's a big problem in the way and in the requirement. So maybe the working statement might be required to some extent to ensure that there are no trolls or non-practicing entities, but the manner in which it is being implemented seems to create a lot of issues and a lot of uncertainties, and maybe there are risks which corporations would not be happy to take.
I'll add to what Rahul said. If you see the Patent Act very carefully, if you do not file the working statement, then you have to pay a fine. But if you file a wrong statement, then you have to pay a fine and you also go to the jail. Now it's opening up the choice to the public, saying that do you want to go to the jail or you just pay a fine. So I mean, I'm just saying that the way it was drafted has not been well thought through. And all the time I feel there's a sword on my neck, I don't know who's going to go to jail. And for faults of none of us, because we really don't know what is expected out of us. And the other challenge that I see with working statement is that, assuming that you have a ongoing license with another organization and there's a confidentiality obligation, it says that you cannot divulge certain information. And if these working statements are out there in the public to see, then you're actually breaching your contract. You would get into other kind of situations which you did not anticipate. So it's a risk from different directions, I would say.
I want to add also that the requirement of working statement has come in the time when we could say that when we have a patent, that very much meant that there is a product and this patent could cover entirely in scope what that product could do. So it is not like today's kind of a product where we start seeing thousands or several patents associated with the product or the systems that we build. If we take 40 years, 50 years ago, we're talking about products, and maybe at that time the important component or the entire product was what we would start covering in the patents. The second thing is, this is one aspect. The second thing is the number of patents that we were dealing with or what was getting filed, they were very small. Today there is a much larger growth. So administratively, what was required or what was the thought? There is a product, you know about the product, you know your markets. It's not like this digital era like where we are talking about hundreds of partners together making a system and distributing a system. It was fairly, the complexity of how we do business was also something different. But what happens is, this has come is now statute, and it is not necessarily the things are changing to suit how we do business or how our products evolve or the systems evolve. So this gap is there which needs to be fixed. If we try to use the formula which worked or which could have worked well, say 30 years ago, and try doing the same now, the only change being that from the manual or the paperwork we have changed to electronic form. If that's the only change that is happening, then there is a issue, because the context has changed a lot. So all the problem that you mentioned or we experience in the day, it gets just amplified. This working statement problem, it's not like here the IP community or all concerned with IP are not aware of. We've not been yet able to fix that. There needs to be a fresh way of looking of how to deal with it. But it is not that you do some increment towards it and it gets solved. I don't think that's the way forward. But till that happens, or we make that happen, the burden part, of course, is going up each year. There's also another complexity that comes in. Good number of patents in India is still filed by the foreign applicants. So what it means is, even like if I take a ABB example, we have several countries from where the invention may be originating, and then we are filing here. And these several ABB entities are being served by various law firms. The working statement requirement is there that the changes what is happening, or the advice would start going to different units. There is a big challenge in how do we harmonize between these different units to start giving information which is consistent. It is the people who are filling out the information, they are often the business people. They are not, the requirement part comes in, it goes to a business unit, or it goes to the IP department. The IP department does not have the business information. So this part would be going to the business teams to say, okay, look, there is a requirement, we need to fill this up, so why don't you give the data? Now, depending on what the business person understands as what it means, he is going to provide this data. Within a company itself, I see a possibility that the data, like what I understand needs to be there and what is actually coming in, there is a difficulty or a challenge in seeing that we have the same meaning. This, of course, would become more complex in the situation which Rahul was mentioning, when there are two different entities coming in. The same entity also there is this problem of, because there are different functions which are involved in providing this data. So the complexity is enormous. I'm afraid somewhere, like even if I have to take some working statements and start seeing, all the data are there, but what do I make out of it? It's a big problem. How should I infer what the data is there? So the risk is that this whole exercise, if not managed properly, could become like garbage in, and the further analysis is like garbage out, or we don't know like which directions it would take. The uncertainty is what starts bothering us. If I give this, or how would this get interpreted? Will it be seen as I'm not complying? So this uncertainty and this fear factor gets much more enhanced. Even if you make, say, two extra day of work, whether we'll be able to solve this problem, I'm not sure. So it's not of, you increase the effort, whether it would get solved, no. For me, it's too complex that the solution is not by having more people or having more processes set in to capture data and put in.
So any other comments? No, so you have comment? No, okay. So I think it's by hearing all these, oh, you have comments?
Well, I just have one more comment, because I think this is something which seems to be a current position of the government. It seems that importation, it's not very clear whether importation of a product is considered as a working or not, and that's a question. Well, in fact, I would be happy if that's the case, because there have been some meetings in the past few months with government officials, and in which it was mentioned that mere importation is not considered as working, but importation is considered. And the question is, what is mere importation? So the question was also tried to be answered, and it was mentioned that if there is importation and at least one step of the manufacturing process takes place in India, would it be considered as working? And then it would be like, then it's not mere importation, it would be considered as working. But the question is, if someone, at least in the pharma sphere, if someone imports the product into India and repacks it, would that be considered as working or not? And that question was not answered. So the point here is that if you say that it's mere import which is not considered as working, then someone could actually import any car manufacturer can import Porsche, and okay, well, because the originator would say that it's mere importation, and then that could also be one of the grounds for a compulsory license, because working is also ground for a compulsory license. So I think this issue about whether importation is considered, as you rightly said, it is considered, but there is still some uncertainty. And I think that also needs to be addressed.
So by hearing all this, I think it is really time to change this. But what we can do as a company, we cannot go and change the law. I think by hearing all your comments, I think it is a time probably for this industry to come together, maybe propose to the controller of patents. You know, this is the time to change. It's really burdensome. I just don't see the public interest is served here. And we can talk about this for hours and days here, you know. So I think that's probably the conclusion here, right? It's a time to change this practice, and probably we should all work together, and maybe to persuade and to convince the government it is time to change this practice. So let's change to a different topic now. And the next topic I want to ask is about the last year. There's quite a few amendments to the patent rules. And first of all, I want to ask a very general question. What are salient features of the new patent rules? How does it impact or change our practice? Let's start with maybe Vipin. You're not sure? Okay.
No, I mean, I haven't looked at the actual rule changes in the patents. So I can't answer that.
Okay,
Sorry.
okay. So, Mikey, do you have any comments?
No.
Well, there's many changes, and some of them we really encourage. We've seen also many changes in the patent office, in the big ambition to have more examiners, to enhance the speed of grant. I think that's really appreciated, because for us it's important that we can see cases proceed to grant, our own, but also those of competition, because that means that we can better assess the IP risk. We are a bit waiting to see how things will develop around the software patenting and the rules around that. That's for us an important topic, because as a company we are moving to more services and solution areas, and across the world there's a lot of uncertainty, and therefore India is not alone. We monitor this worldwide, and we feel that there is a need to have protection for real inventions, whether they are based primarily in hardware or primarily in software, that there should be an opportunity to protect the real creativity of inventors. So in that respect, I think there is some wait and see on our side to see how case law will further develop. We encourage very much all the changes we have seen in making it more attractive for people to file applications, helping SMEs with a tax scheme, etc., because I think this will really boost innovation, will help everybody in innovation to actually protect their inventions. So from our point of view, that is a very positive development, because it will create an IP protection culture. As a company, if we want to acquire technology or want to work together with a partner, or we would like to buy a venture, then it is very helpful if the starting IP position is a good one. And these measures actually, I think, help promote activities around venturing and IP protection. Maybe those are a few topics. I'll leave to others now to further comment.
Cynthia, do you have any?
No comment at this point.
Okay.
Yeah, well, I have just a small comment over here, and well, I leave the major impact of patents to everyone else, to the law firms. But here I want to add here that we know that under the system there was a public notice in 2012, wherein if an application is to enter the international phase via PCT, you're not supposed to change the contents of the application. So the specification, the claims remain the same. Here we have this rule 20, which says that you can delete some claims while entering the national phase, which I think is welcome, because here in India we have this specific section 3, and at least in the pharma field I can say that there have been many applications wherein more than 100 claims have been filed at the PCT stage, and when they enter India, it's found out that out of those 100, only 20 will be patentable in India, because the rest are not going to be patentable. But earlier, we had to enter the international phase, pay the fees, and then delete it at our own. There was no system of a refund. So now that Rule 20 allows deletion of claims, I think that's something which is welcome. But here I have to add one more point, and that was not actually addressed in the rules, and that is there is no possibility of making an amendment to the claims or changing the claims while entering the national phase via the PCT. I don't know why this practice is followed in India, because I don't think that practice is followed in any other part of the world. When you enter the national phase via PCT, you should be allowed to change the claims as long as you have support in the specification. But that's not allowed. So that's something which the rules have not addressed. But at least the applicant can, they do not have to spend on many claims which have been filed and the fees have been paid, and those are not refunded. So Rule 20 at least helps us to some extent.
Yeah, I think the amendment rules are very, very welcome, and there are a lot of good changes. One of the very important ones is the speed of expedited examination itself, which has reduced from 12 months now to 6 months, with an extension of 3 months. I think that would go a long way of speeding up the entire process of how the examination is done and the speed. Also, the number of hearings now is reduced to 2, so and then that would also help in shortening the time span of how things are granted. I think the other things are that they have introduced concepts like the video conferencing, which for people who are not really based at locations where one of the patent offices are there, I think it's a very welcome move. I understand that already in some of the patent offices it's already implemented. Chennai, it's not been done so far, but I understand the infrastructure is already in place, and very shortly they will also start the video conferencing. So I think that's a very, very welcome move in terms of travel, people traveling, their time, and all of that. And other thing, the option of now refunding the fees if you don't file the request for examination. If you decided to abandon a case upfront, then you get 90% of the fees back, approximately. But I think that's all a very good thing, because if you feel you don't have a good search report, you can already abandon the application without having to pay the request for examination and waiting to see what's going to happen. I think on the whole, there are a lot of other points that have been come up, but these were the things that I would say they're all on the right direction and a very welcome move.
Yeah, I was going to say from a U.S. perspective, I think that the reform was welcomed. I think everyone's just waiting for the implementation to see how it actually happens and to see what the specialized patent courts look like and see how the system looks like, to see if it does really get rid of some of the backlog and to push things through faster. One of the other things, I guess, looking at the CRI guidelines, going back to what you're saying about software patents, I guess from my perspective, it's a little bit tricky, right? Because software patents, right, they a lot of times, so I was an ex-computer scientist, used to program back in the day before I went to law school. And looking at software patents, they're generally compared to hardware patents, a little bit more vaguely written, a little bit broader. So I think the whole issue was patent quality issues and the fact that, generally speaking, I've done a lot of IP transactions. Software patents may come in under transaction market a little bit more cheaply than pure hardware patents, and so they were getting bought up by people who were asserting them, and some of them had patent quality issues. So I get that, but I think that requiring a novelty in the hardware it goes a bit far, right? It seems a bit odd from my perspective to do that. So that's just one of the things I think that will come about in case law and sort out how to deal with that. But I guess I see what they're trying to get at. I just think that there might be a better vehicle for that, but that's just my personal opinion, obviously.
Okay, I hear there's several features. Let's deal one by one. The first one is about PCT. When you enter national stage in India, you can delete the claims but not change the claims. I actually have some comments on that. As a person who's doing this international filing for several years, this actually imposes a lot of challenges for international company. Because when you file a application for what is the point you use a PCT filing? Because you can enter in different countries, right? There's a flexibility here. So you cannot like a fire saver, you can only one PCT application. And also, when you enter different countries, if you put a lot of claims on it, there's a lot of money, right? No company have like an unlimited budget for patent filing. And if you limited number of the claims, and we are hoping we have a very comprehensive set like a specification, so later on, we have a flexibility to change the claim, bring new features into the claims. But now in India, the good thing is that we can delete claims so that we don't have to pay a lot of extra patent fee, the claim fees. But you cannot later on change the claims or bring some new features from specification to that. It's making it very hard to predict in the initial stage and what kind of claims you should put in the PCT app. This is